Invite Sri Abhishek Singh, Joint Secretary, Economic Diplomacy Division, Ministry of External, kindly come on the dais. I also invite Professor C. Jairaj, EC member and Director AVIL to join us on the dais. Ms. Krishna Setna, Senior Partner, DMD at Trade. Rahul Dodne has already joined online. Niyati Gandhi and Govindra Ji here. Now I hand over the session to Chair. We are fixing for this session. This session is from 2:30 to 4:30. Please, sir.
Good afternoon, everyone. Distinguished panelist, Professor C. Jairaj, Ms. Farishte Setna, Mr. Rahul Donde, I think he's not there, Mr. Rishabh Gupta, not yet, Ms. Niyati Gandhi, Professor Govindra Ji Hegde, Executive Committee members of ISIL, Secretary General Mr. Narinder Singh. I also see some of my friends, Mr. M.K. Rao, who was also formerly the Secretary General of ISIL, and my good friend and eminent jurist, Mr. Anirudh Rajput. Very warm greetings to all of you. Today's panel is in fact a very interesting panel on international investment law, and that will discuss three diverse topics. First is exhaustion of local remedies. Second one is fair and equitable treatment. And the third is multilateral investment court. Friends, as you are aware that investment treaties have evolved over time from the first investment treaty in 1959 until date. The Indian investment treaty landscape has also evolved from our first BIT with the UK in 1994 to our model BIT in 2015, and the recent BIT is based on the 2015 model BIT. The evolution of investment treaties is because of the backlash that treaties have faced, particularly from the disputes arising out of these treaties. India had its watershed moment in the White Industries case under India-Australia BIT, which were followed by a slew of cases arising out of clarificatory amendments to the tax on capital gains, cancellations of 2G licenses by the Supreme Court of India. Friends, a number of these cases against India, and for that matter, many other states across the world, involve a review areas of law which are generally regarded as an integral part of state sovereignty. Clauses like fair and equitable treatment is one of the most frequently invoked clauses which investors claim as a violation of in the ISDS cases, and this clause has been interpreted broadly by tribunals. The clause means treating foreign investors' investments fairly and equitably, that is, not taking unreasonable or discriminatory measures. However, this is subjective, and each tribunal has applied its own standards to judge if states have violated this clause. India, in its model BIT of 2015, does not per se have fair and equitable treatment clause, but rather has a treatment of investment clause and prohibits the host country from subjecting foreign investments to measures that constitute a violation of customary international law. Investment treaties are quite unique that they provide a basis for claims by an individual person or company against the state. In an effort to avoid the need to turn to national courts for judicial remedy, investment treaties usually contain an arbitration clause submitting disputes to a neutral arbitration tribunal, usually under the International Center for Settlement of Investment Disputes, also known as ICSID rules, or more frequently being arbitration under the rules of the UNCITRAL, or fork in the road provision, which gave the option to the investors of choosing between national courts and international arbitration/ISDS. Friends, the ISDS system has been criticized since because, unlike with the court, there is no appeal available from the decision of an investment treaty tribunal. This can make far-reaching decisions on states' policies and legislations has often been the focus of criticism. The exhaustion of local remedies encourages investors to resolve the dispute under the legal system of the host country before resorting to ISDS. This would also prevent states from being dragged to international arbitration at the drop of a hat. Friends, in the dispute resolution provisions of the new model BIT, the focus has been on domestic remedies, with investors having to exhaust local and domestic remedies, including invoking the jurisdiction of the domestic courts of the host country for a minimum period of 5 years before being able to resort to arbitration under the treaty. This condition is, however, exempt if there is no domestic remedy available to the investor and the only remedy available is under the BIT. The last topic of discussion by this panel is on the proposed multilateral investment courts. UNCITRAL, through its Working Group 3, is discussing ISDS reforms. These discussions include both structural reform, which includes the creation of a multilateral investment court and appellate body, and also the European Union in their treaties have started establishing the investment courts. However, such individual courts created under independent treaties would still be like independent islands and would not really address the issue pertaining to consistency, coherence, and transparency. Finally, the proposed multilateral investment court under UNCITRAL is likely to be discussed in the forthcoming sessions of the Working Group 3. This is an ambitious project and would be too early to comment on. However, leading lawyers have been advocating it. It would be interesting to hear the thoughts of the panelists on this topic, whilst we also follow the deliberation at UNCITRAL. Friends, today is a very interesting day for me also, because I would be chairing a session of, where we have some leading legal minds on this subject. So this would be a session where, somebody who is a journalist like me, a journalist diplomat, would be chairing a session of experts. So I would rather, learn more about, the topics under discussion than, guide a very distinguished panelist. But I must say, I have experienced that our judiciary, our legal fraternity is obviously, looked at with great respect and always kept in high esteem by, our international interlocutors. Independence of Indian judiciary, the caliber of the legal fraternity in India, and most importantly, the way we preserve and ensure that the rule of law is applicable to everyone is something that makes us very different. And look, we are looking at 1.4 billion people, and for 1.4 billion people, the citizens of India, to have such, confidence in terms of the judiciary, in terms of the legal fraternity, it is something which is, we are taking care of 1/6 of humanity in that sense. And many a times during our foreign assignments, we have, received, great respect on behalf of all of you, the great work that the legal fraternity is doing in India, and the independence of our judiciary, the high caliber of our judiciary, that really has strengthened our democratic fabric. And also for people who are, in positions of power or influence, just like, all of us sitting here, who can influence society or through, his ideas or her ideas, and also through the position that they hold. I think the rule of law mirror is very important, because nobody is above the rule of law. And on this very important day, I am reminded of one of the great jurists who I really admire, late Nani Palkiwala ji, and he wrote this book called We the People. And I remember in that book he had quoted somebody else's quote, and that is something which is like a mirror for all of us who are holding positions and who represent the country abroad. And he quoted, and I quoted that quote, and he said that God, give us men a time like this demands, tall men sun-crowned, who rise above the fog in public and private thinking. God, give us men a time like this demand. Of course, when he said men, it means men, women, and all others. So thank you very much, and I look forward to this very interesting session today. And as much as we look forward to hearing them and their innovative ideas, we will also have some time for some interactions also. So on this note, let me go back to my chair, and the panelists will have the option to either speak from where they are, or they can come to the podium. Thank you. Let me continue my role as a chair for this session. Let me invite Professor Dr. C. Jayaraj. Of course, all of you are aware that he has very long and distinguished career, 30 years of standing at the bar in the 3 Commonwealth jurisdictions with expertise in international law. Professor Jayaraj is currently he's a professor and director of ARU, formerly, okay, I stand corrected, professor and director of ARU Padai Vidu Institute of Law in Tamil Nadu. He has co-edited several books on public international law, non-resident Indians, and private international law. So we look forward to listening to you, Professor. Thank you.
Good afternoon to all of you. Well, I have definitely a student of international law for all my life, and if you spend about 40 years in the career of law, and especially I am not only in practice, I also have some academic interactions, and my life is a zigzag one. I was a public prosecutor till last year for 15 years in 2 jurisdictions. Then I have been an international student all my life. So when I returned, I thought I will participate in the proceedings of the Indian Society of International Law, which is a premier institute in this country. So this year I felt that I should come before you and present some views on the international investment law and the dispute settlement mechanism that is there. But this is an academic inquiry and not a practitioner's insight into the matter. That I make it very clear. So what made me to have interest in this general topic is that issue of exhaustion of local remedy. You see, exhaustion of local remedy is not invention of the post-World War. It has been there for quite some time, nearly maybe 150 years or so, and is a part of customary international law. But today, like the chairman told, it's a question of sovereignty, and I feel that there is a constant conflict between sovereignty and international investors, starting from the remedy to the injury of alien, 120 years back and all that. So this conflict is inevitable as long as there is an interaction of a foreigner in a given territorial jurisdiction. But today it has taken forms, that is from individual to property to corporate actors and then even states. So therefore this area is a very interesting one, to see the interaction between individuals and a sovereign country. Now, before going into the, I confine myself to exhaustion of local remedy vis-a-vis the minimum standard and how the Indian bilateral treaty practice in investment area has shifted from one to another legal policy. These are the few things that I want to address today. Now, let us say that the matrix, how much cross-border investment flow is there, that we should keep in mind to know the importance of a legal framework to address the disputes. It's about 1.5 trillion. Well, India receives a good amount of foreign investment, and they say that it's about $70 billion almost every year in various forms. But then, what is the carrier of all these cross-border capital? It's all through bilateral treaties and multilateral treaties, and these are the. But there are certain countries which allow the foreign investment with a policy in place, executive policy in place. Now, one information is that there are about 3,000 bilateral investment treaties. It's all started from 1990 onwards. 90s, 2000, 2010, and now 5 years. In this 3.5 decades, you have got 3,000 bilateral investment treaties in place. So what does it mean? Are they the sources of international law in relation to investment, or one of the sources of international investment law? See, because the exponential growth in treaty and or the treatification of the legal principles of bilateral treaties is a very important one for us. Now, there are also FTAs, as you know very well, in which there is a chapter on investment. Which one is better, FTA or PIT? It is left to the situations of the governments. But now, even the dispute settlement mechanism, that is mainly the ISDS, what is known as the Investor State Dispute Settlement. In 35 years, under the ISIL Convention, I think you have got about 700 cases totally so far. So that the tribunals under ISIL Convention has generated a tremendous amount of jurisprudence. But what is its value? What is its worth in terms of this our own study now? This is certain factors you should keep in mind. The exponential growth in case laws also. Now there are arbitrations under UNCITRAL, International Chamber of Commerce, and so many other institutions there. Apart from that, what is when there are so many 3,000 treaties providing for ISDS and international arbitration outside the territorial jurisdiction, what is left for the municipal courts and municipal legal systems in a dispute between a foreigner and Indian government? What is left there? Almost there is nothing. Because nobody wanted to file here anything in this 30 years. But the thing is that once you enter into 85 treaties roughly and provide for ISDS, the only way is that to raise the dispute outside. And now I am here emphasizing that the blind adoption of the ISDS rule starting from 1994, well, till very recently, maybe 5 years ago, or some of the ISDS, even the repudiated treaties or terminated treaties, they have a sunset clause that will continue for next 10 years or so. So even those disputes, if anything comes, the old, uh, disputes under those treaties, it will still be under ISDS. So, the it is the blind adoption of ISDS at that time, maybe because we, India, wanted, pouring of, the pour down of investment from developed countries. But I feel that I don't know, there a draft treaty in at that time, 1994, when the first BIT was entered into. From Indian side, was there a model treaty or whatever? I don't think so. There was something, but it was the pattern starting from 1994. So this domestic legal remedy has been given a go by government of India, even though it's a sovereign state. It has got regulatory duties. It has got regulatory powers. But despite all that, we have, like so many other countries, Brazil, Argentina, almost every single country, they have also given us the local remedy requirement to dispute settlement, and then they went on with the ISDS. Now, is the situation now for the past 5 years. We will come to that later. But then what are I have said that there is customary international law, there is an international investment treaty, bilateral, multilateral, arbitral decisions, and then maybe one or two judgments in domestic courts. They are all the corpus of jurisprudence in this area. Now, what are the principles that has been generated over a period of time as we stand today? What are the general principles of investment law? That is, that you know the history of expropriation and complaints like adequate, inadequate compensation and all that. Now the principle is that expropriation with adequate compensation. Okay. Now protection from indirect and regulatory expropriation is wrong without adequate compensation. Now fair and equitable treatment. I will not be addressing these principles independently. I will be just mentioning to you. And then there is this most favored nation clause. Then along with the fair and equal treatment, the idea of international minimum standard of treatment, then the most favored nation treatment, exhaustion of local remedies. These are all a few of the basic principles that constitute any bilateral investment treaty. Almost all of them. Maybe there are exceptions here and there which I am not aware of. Now, as I said, I will be dealing with this, the local remedy. Indian, before that, I should deal with what is this local remedy rule. This is basically, I will call it ELR, Equal Remedy Rule. Exhaustion of local remedy rule. So ELR has been there in the part of customary international law. Why the foreigner comes here? How he comes? He comes on his own. He comes voluntarily for travel or investment or business. So when he comes here, which law he should be abiding by? Which law he should be following? If there is a domestic law, he should follow it. But then the problem was that the aliens in about 120, 50 years ago, they got in various forms of injuries they suffered. The general term in international law called injury or harm to an individual. Then it was, the jurisprudence was developing in two ways. That is, that this country of the national argued that there are minimum standards of treatment. There is a basic standard of treatment, irrespective of what is your system or what is your standard domestically. But then it went on for some time, and it went to the extent of about 100 years ago. I think 100 years ago, the thing was that it's the standard of civilization. And whose standard of civilization 100 years ago around the world? It is the so-called civilized states. The standard of the so-called civilized states 100 years became the standard of civilization. If the even or the domestic remedy is not seen as civilized or advanced or equal to that of the home state of the national, it is not acceptable. But it is at that time, went to the extent of sending unable to settle through diplomatic protection. The Western countries, especially the US, used to send gunboats to settle the property disputes between the individual and the sovereign state like Mexico, like several countries. This is called gunboat diplomacy. It was practiced for quite some time, but then at that time there was a jurist called Argentinian jurist called Carlos Calvo. He said, look, there is something called sovereign equality of nations. That means non-interference. Even those days he was very advanced, and you may treat him as a rebel those days, and he was actually treated like that. So therefore, if he said that even those days he was very advanced, and you may treat him as a rebel those days, and he was actually treated like that. So therefore, if he said, that means that an alien who comes here, he has to respect the local legal framework, the local standards of law and justice. There is no question of our country subject to somebody else's jurisdiction. So this particular issue, where to solve the dispute, became a big issue, and there is two levels of jurisprudence. And that one of them, as I said, that exhaustion of local remedy. He says, we don't deny anything, but the local remedy has to be there. First and foremost, it has to be within the territory. Why? What is the rationale of Calvo saying, or even today, Government of India 2016 in the model treaty brings back Calvo alive? What is the rationale behind it? Traditionally, and today even rationally, that the local government, that is the sovereign government, should be given the first chance to redress its alleged injury caused to others. Because what is this today? Expropriation or expropriation by indirect means, using anything from the day one onward, the method is to solve internally and according to the domestic law. But this emphasizes the sovereign equality of nations. Even that was not a law at that time in the law of nations. Okay? So therefore he introduced suddenly the territorial sovereignty, sovereign equality, and primary obligation of the alien to get his wrongs redressed within the domestic jurisdiction of the host country. These are the three primary elements of the what is called Calvo doctrine. As against this one, what started through tribunals, and there's a case called the Neer case, 1926. How many years? It's nearly 100 years ago. There's a standard, even the chairman mentioned it to the, unless it is outrageous, something like that. It's a denial of justice issue. Then they say it is slowly developed into a minimum standard. The minimum standard or denial of justice into even today's concept is carrying on the old philosophies and the old outlooks. Now who is to determine? This is what actually Calvo said. Who will, between you and me, who will decide what is effective means? You said that our means are not effective. Who will decide between two sovereign equality? And because of this, the question of sovereign equality came. So therefore, all these developments went to a corpus of law called customary international law, and that is mostly generated by the arbitral tribunals. You see which case can you cite me one? I don't know, I have not come across. There's a big jurisprudence has been put about the foreign investment, and you know that has become a case law for all of us to follow. So it is the arbitrators. And you see, the problem with the ISDS is that law is always made by a state or an international organization. But then the customary law also develops over a period of time and gets crystallized in the treaty form, or even if it is not crystallized in the treaty form, it stays. But the arbitral jurisprudence, you know, if you take it the tribunals, they are all individuals. There are today, you know, how many arbitrators around the world? I think there are roughly about 3,000, 4,000. I did how many arbitrators are available. It says that 3,000 to 4,000. So all of them is said to be. Now, their jurisprudence is what? I can't rule out that every arbitrator is independent from his client. After all, I mean, even if he is an interpreter, there is an ideological, there is a political outlook to every single investment dispute. If there is an investment dispute between Zimbabwe and India, there will be different arguments. If there is a dispute between UK and India, there will be different arguments. So the arbitral tribunals laid down this decision, which went on upholding anything possibly against Calvert. So therefore, now today, in 1994 onwards, just having put this forth, there are so many rationales for exhaustion of local remedy. There are several of them are there. But anyway, it has also become part of the customary international law. Then there was a conflict around that time. There was no issue that brought it to the fore for our discussion. But then now, the 2016 15 model, issued in 16, tells about the local remedy, mandatory local remedy, exhaustion of mandatory local remedy. It's the first choice given to an investor. And it's very interesting. It also allows ISDS procedure. But if you look at the article, which I read it fully, I underlined, I went on and on to see what does it mean. I request all of you to go through the 2016 treaty, given the definition part of it, and if you come to that dispute settlement mechanism, and when it talks about mandatory exhaustion of legal remedy and Article 15.2, you read it once and tell me what have you understood. I tell all of you. It is so complicated a provision. While mandating compulsorily local jurisdiction, it also provides ISDS. But before you reach ISDS stage and filing an actual claim before an international tribunal, it is such a severe restrictive procedures that are there. You have to wait for 5 years, then after 5 years, you have to wait for 1 year, and then then there is a notice of a dispute issued, and that will be there for 90 days, and then in the 90 days you will have to try negotiation, mediation, conciliation, and whatnot, and ultimately after 6.5 years, you will have to file a ISDS. Now, normally, I have seen this thing, it should not go beyond 3 years to 4 years. Why do you need such a long time, 5 years to dispute? Because it is a specialized dispute. I will come to that at the end of my chapter. It is not a general dispute like human rights, like rent control or something. You know, it's something extraordinarily specialist. Why do you need 4 years? And why do you, what do you have in the place to solve even in the 5 years, 6 years? There is nothing. So therefore, this treaty, model treaty, I don't know whether the government is still keeping it as a only template, or there is some unannounced template for some other agreement which I don't know.
That is the only template.
No, that's the only template officially. But then there is a question to the chair, if that is the official or unofficial, why the Brazil and India treaty went to state to state dispute settlement, and with the internal mechanism joint reconciliation committee. I'm just raising these issues as an academic issue, so that you know what is the pattern in which these things are, the direction in which they are going now. Oh, now that investment, that is not a happy formulation. You can give straight away without again trying so many methods of reconciling with the dispute even after 5 years. There is no need for that in my view. He should be allowed to file a claim outside after 5 years. There is nothing wrong in that. But if everything ends happily within the domestic thing, why you should go there? Now,
Sir, sorry to bother. Since we have other speakers also, I would request you to now conclude and wrap.
Now, having done that one, I would like to suggest certain things. I have a long presentation, but then I will confine to the proposals now. First of all, you must note that the zigzag from customary international law was not tested in DIT. And then DIT produced its own customary, the incorporate customary international law and outside arbitration. Now in 2015-16, you have the exhaustion of local remedy as a mandatory system. Now I would like to raise this question to myself, that if an investor has to have confidence in your domestic system, first of all, we believe in rule of law. It's a constitutional mandate. We believe in due process. We believe in natural justice. It's a time-tested principles that is successfully adopted and applied in India at all levels. If that is the case, what is the legal framework that you have got if an investor really prefers to claim before the domestic court? There is, as far as I know, there is no draft law or model law in India so far to implement the resolution of dispute through the but there are various committees like VN Sri Krishna Commission, that even the Center for International Trade and Investment Law, they have also made so many recommendations. But my proposal would be that why don't we take the existing domestic legal framework of other countries and then take an analysis of that and try to frame a draft domestic law on the entirety of the dispute settlement arising out of investment, foreign direct investment. I would also say that there is a debate going on between, in fact, I'll take 2 minutes. There's a tremendous widening support for the exhaustion of legal remedies in US, European Union, and even European Union has passed a resolution which should do this thing, and third has specifically said in the working group 3, and they are also going to look into the alternates. So, like the multilateral treaty, are we, if we do not have a domestic legal framework, are we ready to go only for state to state dispute settlement as evidenced by the drafted treaty of Brazil and India, or would we like to, as an export, as a capital import and export country, our position is unique, will we participate in promoting the idea of international investment court with the tenured judges, or what is the other way about? I think the government of India should, while promoting its own policy with regard to dispute settlement, also should throw its hat to promote the multilateral investment treaty, so that I think, with the 3,000 treaties in place, you should have a permanent mechanism. I think that will give a very fair and equitable solution. Therefore, I think that we should do homework on the, then I can suggest to the Indian Society of International Law, if possible, it can actually take up this project and then you try to have a legal framework that is suitable. Then you can, the government of India still thinks that there are people in India who can think like this. So you can also engage the, because the VN Sri Krishna Committee has also advised that there has to be international law advisor before entering into a treaty or even after that. So I think with this one, I think whether Calvo won or anti-Calvo philosophers have won, It's a question to be you have to wait and see. Thank you very much.
Thank you. Thank you, Professor Jairaj, for your very insightful talk. Just, I mean, without getting into the details or giving any specific, example, I would like to just clarify that when we look at the model BIT of 2015, that is the starting point of any negotiation. And I have been a negotiator myself at the UN. And Mr. Rao would know that I have also negotiated documents in the 6th committee. So the negotiation, evolves. And with the evolution, the text also evolves. And what is finally signed is the text. So I think I have partially answered your question. But you have covered very well, several issues related to ISDS, local remedies, fair and equitable treatment, exhaustion of legal remedies, territorial equality. You also mentioned about the interesting gunboat diplomacy that was practiced, and also about the customary international law. You also brought back memories of Calvo, if I'm yeah, okay. So it has been truly an insightful, presentation by you, sir, and we look forward to interaction on the topics that you have raised. So thank you very much. Our next speaker needs no introduction, Mr. Farishte Setna. She's a very distinguished member of the legal fraternity and very well respected. She's a senior partner and founder member of the law firm DMD and managing partner of its Mumbai office, heads of the firm's international litigation and ADR group. Ms. Setna has 25 years of litigation and arbitration experience, handling very complex work across multiple jurisdictions in diverse industries. She has, her global reach of work spans many countries, including the United States, UK, UAE, Australia, and many more, and across multiple sectors like infrastructure, banking, finance, to transportation, and many more. Ms. Setna's practice areas include a significant body of taxation work encompassing direct and indirect and international taxation, and she has represented many global majors. So it's a real pleasure for me, ma'am, and an honor to invite you for the next presentation. Thank you.
Honorable Chair, Secretary General of the Indian Society of International Law, Professor Singh, friends. It's a pleasure to be here with you this afternoon. Indeed, a very distinguished panel as well. I have been asked to confine my presentation to fair and equitable treatment. I have put together a few slides so that we can have the benefit of the positions as they stand, as stated in the treaties, and how those have evolved through arbitral jurisprudence within the international investment treaty space. With that presentation on what is FET. No doubt everyone here is well acquainted with the subject. FET forms a key obligation or standard of protection enshrined in international investment treaty agreements. It is found in 95% or thereabouts of investment treaties and reported statistically to form 83% of treaty-based investor-state arbitration FET claims. Formulation of FET clauses have evolved. Hitherto, or what they call the older generation BITs, were broad and open-ended, but more recently we find rather restricted qualified language. In fact, of the type that Professor Jairaj specifically alluded to, which is our experience from the new model BIT that India has put forth, which no doubt, as everyone here knows, is also resonated in the European Commission their position with regard to restricted treaties insofar as concerns ensuring that they are not put through the grind by arbitrators or arbitral tribunals, which may, from case to case, come up with very different interpretations, which clearly do not resonate well with states. An illustration of the FET clause as it stood in Article 3.2 of the India-UK PIT, which entered force in 1995, reads as follows: investments of investors of each contracting party shall at all times be accorded fair and equitable treatment and shall enjoy full protection and security in the territory of the other contracting party. This, as the language would easily suggest, is a rather broad, unqualified position open to liberal interpretation. Juxtapose that with the current version, which sits within, for instance, our India-Belarus PIT. I heard the chair speak to the fact that these are negotiated positions, no doubt. But let's just take a look at this clause, which very plainly would be a very circumscribed scope of the FET. This clause stipulates, no party shall subject investments made by investors of the other party to measures which constitute a violation of customary international law through a. denial of justice in any judicial or administrative proceedings, fundamental breach of due process, targeted discrimination on manifestly unjustified grounds such as race, religion, gender, etc., or manifestly abusive treatment such as coercion, duress, and harassment. I want to pause here for a moment to reflect on what we just heard from Professor Jairaj. Professor Jairaj was tasked with dealing with the exhaustion of local remedies, and we do know that he did identify that there was clearly a need for potentially a model law in India that might address the mechanics that would effectively have to flow in order to provide those local remedies. He also spoke to the fact that clearly what is envisaged is that there should be an internal mechanism to address grievances so that there's a first chance within the jurisdiction where the investment has in fact found its way. Now, I have had occasion to reflect on this mechanism, but my personal views apart, as all of us sitting in India certainly are aware of, we have white industries, and then we have the issue of the ability to address or redress grievances through local courts. And I must admit that I am somewhat bewildered by the fact that India should seek to find an answer through their domestic law regime, particularly in circumstances where we do not have the mechanism to actually deliver on that regime that would be required in order to provide that legal remedy. So the question that I ask myself is, are we effectively, through proposing what we have in the existing model treaty, actually finding a way to ultimately find ourselves faced with more denial of justice claims, which would very clearly be the necessary consequence if we were to not have the kind of model law that Professor Jairaj spoke to, or any other form of mechanism that would necessarily have to address this gaping hole which currently exists. But be that as it may, the question is, how is FET interpreted by international investment treaty tribunals? The FET standard is a dynamically interpreted standard which is intended to allow for deliberate flexibility, which then is adapted to the circumstances of each case. Tribunals have concluded that the ordinary meaning of fair and equitable treatment means just, even-handed, unbiased, legitimate treatment, as was effectively laid down in Siemens versus Argentina. A noted authority has commented, lack of precision may be a virtue rather than a shortcoming, since it allows for independent and objective third-party determination of a respondent's behavior on the basis of a flexible standard. What are then the facets of FET? The FET protection principally encompasses fundamental standards developed through a growing body of jurisprudence allowing, as I've mapped it, for 6 core principles to emerge. There's of course the jury is out on whether there's many more, but here's how I've ordered them. The first being legitimate expectation. No doubt, legitimate expectation of the investor when he puts in his investment dollar into the capital importing state. The next being non-discrimination and non-arbitrariness. The third being stability, predictability, transparency and consistency. Good faith, due process and denial of justice. Those are the 6 core attributes or facets of FET. What is it that constitutes legitimate expectations? These, as I just alluded to, are generally based on the host state's conduct and representations, often in the form of oral or written statements, or reliance on legal and administrative frameworks in force at the time of making the initial investment or expanding an existing one. In Mikula versus Romania, very recent jurisprudence, it was observed that where the state has acted in such a way as to generate a legitimate expectation in the investor, and that investor has relied on that expectation to make its investment, action by the state that reverses or destroys those legitimate expectations will constitute breach of fair and equitable treatment standard and thus give rise to compensation. Non-discrimination and non-arbitrariness. In CMS Argentina, it was recognized that any measure that might involve arbitrariness or discrimination is in itself contrary to FET. To amount to discrimination, a case must be treated differently from similar cases without justification. It must be discriminatory and expose the claimant to sectional prejudice or a measure that must target the claimant's investments, specifically as foreign investments. Notions of arbitrariness are prejudice, preference, or bias substituted for the rule. This is a position that has been laid down in Joseph Charles Lemire versus Ukraine. We come next to stability, predictability, transparency, and consistency. The state is under obligation to act in a consistent, unambiguous, transparent manner, that it must maintain a stable environment to reasonably permit for a diligent investor to adopt a commercial strategy and must act in a non-arbitrary and non-discriminatory manner without misuse of powers and in compliance with commitments. This is the position laid down in Lessi versus Algeria. The Arif versus Moldova tribunal found inconsistency between attitudes of different organs of state in itself, amounting to a breach of fair and equitable treatment standard. In Techmed versus Mexico, that investors should know beforehand any and all rules and regulations that will govern its investments, as well as goals of relevant policies and administrative practices or directives, to be able to plan investment and comply with regulations was effectively the threshold acceptance measure for stability, predictability, etc. Good faith, of course, the bona fide principle, as recognized by the Techmed Tribunal and similarly summarized in SIAG versus Egypt. Due process, which forbids unfair proceedings by biased decision makers, conduct that does not offend judicial propriety and complies with due process and the right to be heard. Metal Plant versus Mexico and Rumeli versus Kazakhstan were clearly cases where there was no real possibility for a claimant to present its case. That standard, the FET standard, insofar as concerns due process, was found to have been breached. Denial of justice. I've spoken to this briefly, so I won't labor this slide, except that malicious application of the law doubtless overlaps with the notion of pretense of form to mask a violation, as held in Azanian versus the United Mexican States, and similarly in SIAG versus Egypt, where there was inability for the government to permit for judgments to be enforced by the claimants. We have similarly a finding of denial of justice. Breach of legal certainty, we have Kane versus Republic of India, December 2020. This, as everyone here knows, was preceded by September 2020 Vodafone. Kane had argued that the 2012 retrospective amendment to India's tax laws effectively created a retroactive tax burden contrary to the FET protection. The tribunal found in favor of Kane. In fact, in that case, the tribunal noted that the FET standard is an autonomous one and a state may breach the FET standard by conduct that is arbitrary, unreasonable, discriminatory, and involves a lack of due process. No doubt everyone here is aware that India did challenge that award. That matter finally settled in 2021. Coming then to enforcement of laws consistently. Coming back to Mikula versus Romania, this was a case concerning the sale of alcohol, spirits, and related activities in Romania, where a claim was brought for breach of FET. With regard to failure to enforce tax laws, the tribunal dismissed the claim.
Sorry, ma'am. You
Am
can
I
just.
out of time?
No, I mean, just you can now start.
Sure, I will start that. The claimants argued that a denial of legitimate expectations that Romania would enforce its alcohol tax laws was bound to effectively be found in their favor. Those acts and conduct were ultimately found to be acts of general legislation, with specific actions taken by Romania relating to the enforcement of taxation legislation, concluding for the tribunal the difficulty in finding specific and sufficient precision in the expectation that would give it the ability to attach liability. Similar position insofar as concerns Mohammed Abdel Baghet versus Egypt, which is a December 2019 award in regard to denial of justice, where it was found that in view of the state Supreme Court having found that the claimant's arrest, prosecution and incarceration lacked probable cause, that by itself should be reason for the international tribunal to effectively conclude that there was in fact no probable cause for the actions against the claimant. I'll skip the next two slides, going over to the last, where I want to state in favor of India that the European Commission has stipulated that a closed text which defines precisely the standard of treatment without leaving unwelcome discretion to the members of the tribunal is the need of the hour. That, in my respectful submission, very clearly, in fact, resonates perfectly well with the India Model Treaty, and I do believe that the India position has now far wider acceptance from multiple states across the globe, and I do believe that, notwithstanding all of the criticism that we have laid out insofar as concerns the lack of a mechanism, it does appear that that is the way forward, because states are clearly not inclined to have any form of interference with their sovereignty, and increasingly states are, and of course the multilateral courts are expected to address that issue somewhat, but ultimately states are not inclined to continue to remain exposed to PITs, and I do believe that that is the correct position that India has taken, and I endorse that fully. Thank you for your time.
Thank you, ma'am, for a very deep and insightful explanation of the fair and equitable treatment. You've covered many facets of FET, including, legitimate expectations, arbitration, good faith, due process, denial of justice. You have given concrete examples of all these, and also towards the concluding part, you have said some very positive and warm words for the India position. So thank you very much. And now we move to the next speaker. I think he's going to join us through VC, Mr. Rahul Donde. He is a counsel in Levi Kaufman Kohler. He specializes in international commercial and investment arbitration. He has acted as arbitrator, counsel, secretary, and assistant to the arbitral tribunal in over 35 international arbitration proceedings under both ad hoc and institutional arbitration rules. Mr. Rahul Donde is an honorary lecturer at the Aberdeen University. He has co-edited the first ever TDM special issue on dispute resolution in India. He has held leadership positions in several international arbitration organizations, including Young ICCA, and is regularly invited to lecture, speak at conferences, and conduct workshops in international arbitration. It's indeed a pleasure and honor to invite our next speaker, Mr. Rahul Donde.
Thank you very much, Honorable Chair, for the very kind introduction. Thank you also to the Indian Society of International Law and its office bearers for inviting me to speak today. It's truly a pleasure. My sincere apologies for not being able to be present there in person. I would have very much liked to exchange thoughts and ideas with all of the distinguished minds in the room. My apologies for not being there in person. Thank you also to everyone that's attending. In person, it's a difficult session in the afternoon, made all the more difficult today because we're about to see the start of the India-Pakistan cricket match. The topic for my presentation today, and I'm going to quickly share my screen. If I can I ask for privileges to share my screen, please?
With us, Mr. Donde, he is putting the system in place.
Sure. It was enabled earlier, but there seems to be a glitch just when we need it.
Can I request Mr. Secretary General to coordinate this? Me? So as Rahul has mentioned, and since we are waiting for the PPT, I think a very interesting match is awaiting all of us. When does the match start? Thanks for reminding me. When does it start?
I think it's supposed to start at 3 or 3:30 India time, if I'm not mistaken, but I'm not entirely sure if it's not already started. I know that there was rain, so the start was supposed to be delayed. I'm not sure exactly what the start time is now, given the weather.
And it's a 50-over match, the Asia Cup, or 20, T20, no? 50
No,
over.
it's a one-day international, so
One-day
it's
international.
50 over format.
So now
Maybe I can already start while we wait for the presentation. I think I can already begin. The topic of my presentation today is really the reforms in investor-state dispute settlement. And I heard earlier that there's an interest, at least, in focusing a bit on the multilateral investment court. And of course, I'm happy to do that. My presentation is divided into a number of parts. The first part, I thought it would be useful just to overview the current state of investor-state dispute settlement, where exactly we are, which countries are seeing a large number of disputes, which countries are seeing, what the general outcomes are. Do win more than states do? What is the general state of investor-state arbitration? I then thought that we could briefly discuss a few of the substantive reforms in investor-state dispute settlement that are currently being discussed. And we've heard some of this already in the earlier presentations, where we've heard that the FET standard, for example, has been altered, I would say substantially altered over the past couple of years. So we can consider a few other substantive standards that have changed in the last 5 years. Then we can consider the procedural. Reforms that are currently ongoing. And this was already mentioned by the Honorable Chair in his opening speech. He spoke principally about the Once Trial Working Group, and the working group is of course doing is taking a lot of steps to reform the current investor-state dispute settlement system. Finally, I thought that it would be useful just to consider the Indian position. Where does India stand in terms of its investment agreements? Where does it stand in terms of its existing disputes? And of course, finally, where does it stand in terms of the reform measures to the extent we have them? There have been a large number of, I would say, developments on the Indian context over the past couple of years. There's been the model BIT. There's also been a joint interpretive note that has been proposed to a few treaty partners. There has been the constitution of an intergovernmental, let's say, entity or institution or panel to efficiently address investment claims. There's been a proposal, in fact, a call that was made for empaneling both foreign and domestic law firms to represent the Indian government when it comes to its investment treaty arbitrations. So I thought that we could consider that. I am still unable to share my screen. If I can just ask for the individuals in the room, if they can just make me the host of the meeting, I think that should solve the problem. I could do it earlier, so I don't understand what has happened now. Yes, it's done now. It's done now. Thank you very much. I hope you all can see my screen at the moment. There we go. That was the outline of that I just spoke about. In the interest of time, I'm going to move very quickly through the first couple of points, and that is really the current state of investor-state dispute settlement. We'll see from statistics that were at least produced in 2021 that when we think of investor-state dispute settlement, by far the largest number of disputes that arise are from bilateral investment agreements, and you'll see that that holds a lion's share of the field of investor-state dispute settlements. So bilateral investment treaties really form the basis of those disputes. In terms of bilateral investment treaties itself, you see that there are a large number of investment agreements that are in force, a large number of agreements that have been signed but that are not yet in force. And we've heard from the first presentation today that is about 2,500 investment agreements in total that are in force. In terms of investor-state dispute settlement cases, you'll see that there was there have been spikes in the number of cases that have been seen. So you'll see that a large number of cases were filed in 2020, 2021. The number of cases, new cases filed in 2022 has reduced. There are, of course, reasons for this. We don't have the time to get into it. But largely between, I would say, 2019, 2021, we had a large number of disputes that were filed against principally European nations concerning their renewable energy programs, especially in the photovoltaic sector. In terms of which countries are most frequently sued, you have that more or less on the screen in front of you. This figure has of course changed slightly over the past couple of years, but in general you have the figures there. You will see that India has a fairly large number of disputes. It has been the respondent in a large number of cases. In terms of the investors, the home state of the investors is largely coming out of the United States or the UK, or the Netherlands. In terms of regions, you will see that investor-state dispute settlement is kind of spread all across the world. You have disputes from Central America and the Caribbean to Eastern Europe and Central Asia. I would say a vast majority of disputes are increasingly seen in Eastern Europe and Central Asia. In terms of industries, and we're talking about the current state, you'll see that investment disputes cover a wide variety of industries. You have oil, gas, and mining, which historically has been the highest, but you're increasingly seeing other industries, including tourism, finance, and of course electric power, that are coming up. So that's the general state of play of investor-state dispute settlement. The final slide I have on this is in terms of outcomes. So you'll see that at least as of 2022, a majority of cases, investor-state dispute settlement cases, were decided in favor of the state, 37, and 28 or so were, in terms of percentage, were decided in favor of the investor. So that's the general state of investor-state dispute settlement as we have it. Many of the people in the room will know that the investor-state dispute settlement system has come under criticism of late. There were a large number of criticisms which were made, and as a result of which there were some reform actions which are being discussed. Some of them have already been put into force, and we see some developments both in terms of the substantive law that is applicable in investor-state dispute settlement, the substantive standards that are applicable, and also some procedural developments as well. So in terms of the substantive developments, I would say one of the critical developments is that increasingly we are seeing that bilateral investment agreements or international investment agreements that include multilateral treaties that have investment provisions are being terminated. We have a large number, and you can see this on the screen in front of you, a large number of treaties being terminated over the course of the last decade. In terms of what we see in terms of the new features or the reform features in recent IIAs, you see that the newer treaties have a strong emphasis on the right to regulate. So over the past, I would say, 10 years or so, the substantive protections which are provided in the treaties have undergone quite a change. The recent generation of treaties have changed the language of certain substantive provisions, for example, fair and equitable treatment, but also national treatment, most favored nation treatment. There is an increasing right which is provided by states, provided to states to regulate, and this is very clear from the figures in front of you. We also see that a large number of treaties have reformed or completely omitted investor-state dispute settlement, and I think that that is an important development as well that has occurred in the recent past. Now, if we are to consider what these changes actually are, we can see, for example, evolution in certain substantive standards, like, for example, national treatment. Now, earlier, national treatment was simply mentioned as such in the investment agreements that were entered into in the 90s, including in some of India's BITs. But now, national treatment is far more circumscribed. You have on the screen in front of you an example of an agreement that was entered into in 2018, and you'll see that I would say certain disciplines of international trade law are increasingly being brought into investment law. You have a narrower definition of what constitutes, for example, like circumstances. You also have a larger number of reservations that you see in investment agreements, and these are all developments that have happened over the course of the past 5 to 8 years. You will see that, again, when you consider national treatment, you have government procurement, subsidies, grants, and other measures which are being now excluded. All of this is occurring, which is different from the practice which was followed in the 90s, where again national treatment was broadly worded. You're seeing a narrower circumscription really of the substantive standards of protection that are being offered to foreign investors. Another big shift, and we've already heard this, so I'm not going to belabor the point, is on the fair and equitable treatment standard. Earlier, it was simply mentioned that an investor is to be provided fair and equitable treatment, or is to be treated fairly and equitably. And now you find that the fair and equitable standard is increasingly being pegged down. It's being circumscribed. You have targeted discrimination, denial of justice, which is again circumscribed, and other measures. Again, this is something that is reflected also in India's model BIT, and we will talk about this shortly.
Rahul, can you please wrap up? Sorry,
yes.
sorry.
Sure, I'm just going to quickly, I think in the interest of time, I think I can quickly then turn to the multilateral investment court, which is what was mentioned earlier. And the multilateral investment court, of course, has multiple facets, and it's not possible to go through all of these facets in the time that I have. But this chart here on the screen gives you a good example of the multilateral investment court, which should be, I mean, what I put on the left of the screen is the CEDA tribunal, but the multilateral investment court is not very different in the sense that it will also have a president, a vice president, 15 judges, and as opposed to the current ICSID system, where the parties choose who the judges are likely to be or who the arbitrators are likely to be. When you have the multilateral investment court system, you will have the appointments being made amongst the 15 judges that are appointed by the member states and not directly by the parties. And that is a considerable change, and that has led to, I would say, a lot of discussion, a lot of conversation amongst individuals. India has opposed historically the multilateral investment court. Maybe the position of the government has changed over the past couple of years, but at least initially the government had a lot of hesitation. In the current discussions that are ongoing between the EU and India considering their investment agreement, I understand that the EU has proposed something similar to what is present in the CETA that is on the left of your screen, and negotiations between the EU and the Indian government on that and other issues are still ongoing. In terms of the criticism of the multilateral investment court, it is considered by many to be ISDS. It's again a sheep, a wolf in sheep's clothing. You do have a lot of criticism being advanced, and I'll just leave this on the screen for the audience to consider. Again, the multilateral investment court has not reached fruition yet. It is an important reform measure which is being considered, and the Indian government has taken a position on this. I think with that, given the interests of time, I can stop. I did have a couple of slides concerning India's position. Overall, I wanted to say that India has now terminated a large number of its BITs. So we have 86 in total, about 76 have been terminated, 8 are currently in force, 2 have been signed and are not in force. And of course, the treaties that are terminated, some of them have sunset clauses, so they are still technically, new investment claims could technically arise under those treaties as well, but that very much depends on a case-by-case basis. The government has undertaken certain, positive steps, and I have this over here. We have the model BIT, the interpretive statement, the termination, intergovernmental agencies being constituted, designation of external counsel, and Indian courts also recognizing to some extent international investment law and pointing out certain potential inconsistencies between the existing legal framework that we have within the country, commercial arbitration, investment arbitration, and the interaction between those two disciplines. Sorry for this very rushed presentation, but I thank you all for your patience, and of course, if you have any questions, I'm more than happy to answer them. Thank you.
Thank you very much, Mr. Rahul Donde, for having consideration for the time, because we have 3 more speakers, and I want to once again thank you for your insightful views on investor-state dispute settlement. You talked about the current status, about the big shifts. You also touched upon issues pertaining to the multilateral investment courts, and we are very thankful for your exposition of the India position also. Now we turn to our next speaker. In fact, we have 2. They are making a joint presentation. But Rishabh Gupta, barrister at 20 Essex at Shardul Amarchand Mangaldas, is not present, and Niyati Gandhi is there, and Ms. Gandhi is, of course, principal associate in the dispute resolution team at Shardul Amarchand Mangaldas and Company, and she has assisted in the establishment of the Mumbai Center for International Arbitration. She has acted as a secretary to the drafting committee for the MCIA rules and formerly served as the co-chair of the Young MCIA. because we have, we have around a little over half an hour left for concluding this session. So I would request the speakers now, presenters now, to stick to around 7 to 10 minutes, and then we want to keep around 10 to 15 minutes of interaction. So over to you, Ms. Gandhi.
Thank you everyone for giving me the opportunity to speak today. I'm sorry Rishabh is not here, but okay, so anyway, because I'm towards the end of the panel and I'm very well aware of how dry investment law sounds, I'm just going to try to tell you a few interesting things that I found along the way while I was preparing for this presentation. Because I think you've heard everything from speakers a lot more senior than I am about the substantive content of the law, so maybe I'll just leave you with some thoughts. The first thing that I wanted to talk about or draw your attention to is that the reason we entered into bilateral investment treaties is because we believed that they would positively impact investment. Over the years, what has happened, and particularly in the context of the discussions on the termination of bilateral investment treaties, is a lot, and literally there have been 75 empirical studies on whether investment treaties actually have a positive impact on FDI. There is somebody who has done a meta-analysis of the 74 studies, made the adjustments, corrections, etc., and found that the effect of bilateral investment treaties on FDI is almost zero. The second thing is, now that we know that the treaties are not that material to attracting foreign direct investment, what I want to then tell you is what Rahul has already told you, but maybe in a slightly different way, which is who really wins investment treaty cases, right? And that really will give you the context of why we are here today having this very long discussion about why this system needs to be reformed. First, you should see this chart, which will tell you that the states that are being targeted are being heavily targeted in investor-state dispute settlement. That is typically due to a particular measure that the state has taken. For example, Argentina had to nationalize a lot of industries during a financial crisis. Consequently, Argentina was hit by a slew of cases. India has faced 16 cases. As Mr. Singh said at the very beginning of this presentation, that some of them arose because of key items such as the clarification on the capital gains tax in the Income Tax Act or the cancellation of the 2G licenses. Again, I told you that I would tell you who wins investor-state arbitrations. If you look at the chart I'm showing you, you will see that it seems that states are winning investor-state arbitrations. Like 40% of them are decided in favor of the state, 20% have been settled, 12% have been discontinued. But that's actually not the right way to think about this, because in all of these disputes, you begin obviously only for leverage. You begin these disputes for leverage. There's going to be a settlement, there's going to be a jurisdictional challenge, there's going to be early dismissal. There are very, very few cases that are left over that are thought about on merits. And when a merits decision is made, 56% of the cases are decided in favor of the investor. So the complaint that is really arising is that is the system designed to favor investors? The main culprit, I would say, of the system being designed in favor of the investors seems to be the fair and equitable treatment standard. Again, that's why we were talking about it so much today. Because 83% of the claims that I just showed you are actually claims for breach of the fair and equitable treatment standard, which means that all of these cases investors are winning on the basis of this ambiguous standard that investors should be accorded with fair and equitable treatment, which in itself are words that mean nothing at all. They are just words that have been given meaning by some arbitrators over the years, and suddenly we find it becoming precedent. Now, I think we've already covered that the model BIP is circumscribing the scope of the fair and equitable treatment standard and specifically telling you what should remain in it. That seems to be the preferred approach. I think Rahul also showed you a slide very quickly, which was that the Canada-EU CETA also follows this approach, and the Canada-EU CETA has this circumscribed FET clause. I'm going to skip over everything else I was going to talk about under the FET section, and I want to tell you again that there is an enormous backlash ongoing in the international legal community against the investor-state dispute settlement system as it stands today. The backlash is coming from the states. And why is this important? This is important because this is one of the only places in international law or public international law that you see corporate individual entities have locus standi against states. And states are therefore liable to these individual entities. And can I tell you that the average award that is being awarded in these proceedings is actually over $1 billion. Again, the math is a little bit skewed on this because there have been a couple of awards that have gone over $50 billion. Even if I remove those numbers aside, the average award is $350 million. That is way above the annual education budget of the government of India. And that's why it's important to be talking about this today. What I want to tell you is that generally, consensus-wise, the three key problems that states are raising is first, costs. Of course, the size of the award is a very, very big problem. Second, the cost of even litigating these proceedings is very high, and there are claimants that are starting these proceedings at the drop of a hat. I'll give you an example, and this might just be hearsay, but the cost to India for litigating the Cairn arbitration was close to $10 million, and the counterparty had claimed over $25 million. That's ridiculous. The second thing that we can, and actually, again, just to give you some more context, the prices are so high because there are very few people who are practicing this, area of law. It's, our government, our panels are constantly saying that educate yourself on this area of law. A, it's very well paying clearly, but B, it's necessary for us to be educated on this so that we can be running these proceedings and we don't need to invite the foreign lawyers here anymore. And I've put some numbers on the screen as well. This $50 billion awards that I was telling you about, the bill of only one side was $75 million. Now that I've covered costs, let me tell you the second also very, very big problem, which is sovereignty. Again, there are just three individuals, 85% of which are from Western developed countries, who are framing the law on this issue. They are literally sitting in judgment over government policies that are being made for the betterment of the state. Right? Like, for example, we talk about the cancellation of the 2G licenses. They were cancelled because the policy of the state in offering them was wrong. The judicial system was correcting it, and for that correction, we should not be bearing such costs. Right? Another point is your tax law. Why is an arbitral tribunal sitting in judgment about your ability to tax whatever it is that you want to tax in your state? There's a tax lawyer on this panel, so I shouldn't have said this, but somebody has to say it. And the third point really is regulatory chill. I think I did speak to this a little bit, which is to say that if you are afraid of such high costs, if you know what size of award is coming because of this, you are going to hesitate to pass policy that is required, and that's probably going to be required by people with less agency. Like, for example, you're going to be passing these policies to protect the climate, you're going to be passing these policies to protect specific marginalized communities. It might be impacting business, but you won't take those steps because you will be afraid of the cost of taking those steps. This is what we are calling in international law regulatory chill, and it's really important that a state be able to govern, especially a developing emerging economy, be able to govern without such limitations. Okay, I think I just wanted to mention the ongoing negotiations. I know India's position on treaties is actually now very, very strong. We are negotiating from a position of strength. we are probably, and we should be the loudest voice in the room for developing economies. And it's going to be a test of what we can actually negotiate for the developing economies in terms of what we are going to be able to include in the Australia EU FTAs. Finally, the ongoing reform process. There is an ongoing reform process going on at the Ancestral. Our brain tends to think that these reforms at these international agencies are a question of majority. It's not a question of majority. The Ancestral requires unanimous agreement of all member states at the Ancestral. India is one of the members at the Ancestral, and the question of whether or not there is going to be a multilateral investment court, India is going to be able to control the outcome of that process. In the India-UAE FTA, there is a provision that we will subject our disputes to the multilateral investment court, and they were going to amend that provision at a later stage. But that's not happened yet. So it looks like India is interested in a multilateral investment court, but there are many issues with it. The only issue I want to raise at this moment, with the limitations of time, is that the multilateral investment court is only solving some procedural problems. The real problem is in the substantive law, and that is only going to be resolved through negotiations from our position of power. Thank you.
Thank you. Thank you very much, Ms. Niyati Gandhi, for covering this important area of FET, giving a developing country's perspective. You have also given some practical suggestions and also your warm words for our India position. Thank you very much. And the last speaker of the day is Sri Govinda Rajaji Hetide. He is an associate professor of international law at the National Law School of India, University Bangalore. His area of expertise are private international law, international commercial contracts, international trade law, and general principles of international law. He is EC member of the ISIL. So welcome, Mr. Hegde, and over to you.
Thank you, sir. Good evening. I shall avoid my tuberculosis rules 7 to 10 minutes. Being the last batter, I think it's applicable to me. Let me see how best I can navigate through the subject which I have mentioned here. The subject is enforcement of investment arbitration agreements and arbitral awards. I begin by the judgment of the Delhi High Court in Vodafone case, Union of India versus Vodafone Group PLC, 2017 decision. And then, in a way, the matter went up to the Supreme Court, but the Supreme Court did not take up the matter on merits. Those who are conversant with enforcement of arbitration agreements and arbitral awards would know that in international law system, the New York Convention rules the roost. The New York Convention of 1958 deals with the recognition and enforcement of foreign arbitral awards. There are several provisions. It's a very shortcut international convention, but most effective one as far as the enforceability of the arbitration agreements and arbitral awards are concerned. India is not a party to the ISIL Convention, that is the International Center for Investment Disputes. That is popularly called as Washington Convention of 1965. And hence, a question is raised. In case of investment arbitration, generally, whether investment law or investment dispute, would it come under the scope of the New York Convention? This is a serious question. That is the question put to us by the Delhi High Court with some or no help from the Indian Supreme Court. The issue is important for a country like India, as it expects foreign investment to flow into the Indian territory, and that's the objective. But the point for discussion which I would like to raise here is whether the Indian judiciary I include both the Delhi High Court or maybe other high courts in the country, along with Indian Supreme Court of India, the Supreme Court of India, whether Indian judiciary has lost a golden opportunity to deal with an important issue such as bringing the subject matter of investment dispute under the scope of the New York Convention of 1958. I mean, this question assumes significance for the very reason that India is not a party to the ISIL Convention. So what is the legal facility available in India for the enforcement of investment arbitration agreements as well as investment arbitral awards? Going by the decision of the Delhi High Court, one would understand that the only route available is the civil, the CPC route. And going through the CPC route is quite cumbersome. There are two provisions, Section 13 and Section 44A. Legal grounds applicable to the enforcement of foreign judgments. In other words, once the arbitral award has been rendered abroad, it has to be subsumed into a foreign decree. It has to be converted into a foreign decree or foreign judgment. Then only it can be brought under Section 13, or in some cases, if there is a reciprocal arrangement between India and that country where the arbitration had happened, then the subject matter can be treated under Section 44A. That is quite cumbersome. So that is the importance of the question which I am raising here. Very briefly on the other points. History of international commercial arbitration, much before that, history of the development of international commercial law is important in understanding international commercial arbitration. Similarly, the development of international investment law and the concept of international investment arbitration. These two are seemingly different. If you look at the origin of law relating to international commercial transactions, that led up to a dispute settlement mechanism called international commercial arbitration, you will see that it starts from the city-states. So it goes back to several centuries. A private commercial transactions. There is no involvement for state. Even till today, states are by and large, their role is absent in the case of private international commercial transactions. That's not the case with the subject of international investment law. The various stages in the development of these two disciplines can give us an idea that to some extent certain legal concepts are similar in the field of international commercial arbitration and in the field of international investment arbitration. But after traveling some distance, they take different courses. The two disciplines are quite distinct, as eloquently argued by Prabhash Ranjan in a blog post very recent. Now the history part is very important in understanding where we are today as far as the subject which I have mentioned here. The question which I would like to answer now is whether Indian judiciary has, left a golden opportunity presented to it. It's all very well understood that domestic cases are normal. That means they are regular. Such cases come to before the Indian courts every now and then, but not international cases or transnational cases. Abnormality evokes interest, and that is the question which we are addressing here. In my opinion, a Delhi High Court would have, instead of resolving the issue by saying that an arbitration arising out of BIPA, bilateral investment promotion agreement, would not come under the New York Convention, it has closed the door for any legal issues pertaining to the enforcement of arbitration agreement as well as enforcement of investment related arbitral awards. I think that is the implication one would get, and it's a more serious one. So the legal situation as of now in India is, should a country like India wait until another case comes up before the Indian High Courts first and then the Indian Supreme Court, or would it become pertinent for a country like India to go for a sui generis legislation maybe on the lines of New York Convention plus ICSID arrangement for the enforcement of ICSID arbitral awards, and then the legal regime applicable to the subject of international investment law would be complete. Otherwise, the present legal mechanism seems to be very archaic and it is heavily compartmentalized. This is not the only thing. Suppose, had the Delhi High Court decided the issue in favor of bringing subject matter of international investment within the context of the New York Convention, probably it would have been possible to balance the sovereign right of the host nation with the rights of the foreign private investors. I mean, in any international engagement, there is give and take. No one can enter into a contractual relationship with one's own terms and conditions. I think I take a middle position here that India has made a declaration, commercial reservation clause. By a nuanced interpretation of the commercial reservation clause, it is still possible for the Indian judiciary to say no kinds of investment-related arbitration agreements as well as investment-related arbitral awards. I mean, I don't want to go to the discussion on the interpretation of the word commercial by the Indian Supreme Court, starting from Kamani judgment of the Bombay High Court and then the organic case, later the RM Investment Company case decided by the Indian Supreme Court. Kamani judgment is still, it has not been overruled by the Indian Supreme Court in RM Investment Company case. I think now the issue before the Indian policymakers is, should India move forward with sui generis legislation for the purpose of enforcement of investment arbitration agreement as well as investment arbitral awards, or one should wait until the apex court of the country come out with a possible judicial solution to the problem. Thanks.
You want to add anything?
No.
Thank you. Thank you very much, sir. Professor Govindaraj G. Hegde, for your insightful views on enforcement of investment agreements and awards in India. Talking about awards, I think the model BIT of 2015, what I recall is that the awards under this would be treated as the awards under the New York Convention. So, but of course, you have given many new facets and discussed new facets about it. We can have maybe some questions on that. Before we go to the Q&A, I will use my chair's discretion to invite eminent jurist Anirudh Rajput. You are aware that Anirudh Rajput was the member of the UN International Law Commission between 2017 and 2021. We were all part of the, the great election victory that was, done in New York, and he, of course, he worked very hard for it, and he worked very hard in the commission, and he was also the chair of the drafting committee of the 69th session of the ILC in 2017. He's a very eminent litigation and arbitration lawyer, and he has also practiced before the Supreme Court of India. So Anirudh, can I request you to share your views? We have some limitation of time. You can come over here. Yeah. We are taking advantage of your presence. Thank you.
Once you're on the podium, then you don't want to leave. So I wanted to stay down, but I must thank very much. I'll be extremely brief. I know the India-Pakistan cricket match is more interesting than what I have to say. I must thank Mr. Singh. He, as I just said to Mr. Rao sitting next to me, he hit all the right chords about investor-state arbitration and all the points that he made. I must also congratulate ISIL for this excellent exercise it does through its conference, and its very able Secretary General, I think, who's a distinguished scholar himself, my predecessor was a commissioner. I must congratulate him as well. I'll make very brief points. I think there are two interesting and complicated facets which also need to be elaborated a bit when I was sitting in the audience and reflecting on the 2015 model BI. I try my best to defend it as much as I can because I had the immense privilege of being a part of the law commission which reworked on it with, of course, Mr. George Potan and my very dear friend Prabhash Ranjan. We sparred on several occasions, but I think some of those aspects are important and need to be upheld, need to be clarified, which I did in one article called Safeguarding India's Regulatory Freedom. Forget where it was published, but it has some of those points, and I'll just very briefly highlight them. The first point is about why there is no fair and equitable treatment standard. There is no fair and equitable treatment standard in the model DI. I call it an abridged fair and equitable treatment standard because what it tries to do is codify the elements of fair and equitable treatment standard as it emerged from customary international, because that gives a certain degree of guidance. The move is that the investment tribunals are going all over the way, all over the place. So you need to direct them. So state practices aimed at aligning, disciplining, telling them what we mean by a certain standard. So don't go too far. So that was the first purpose. We got rid of most favored nation treatment because I remember Michael Wiesman said once, can you make a dream treaty through MFA? The reason why India lost its first case was because they said, well, there's no breach of denial of justice because it's a very high standard, rarely met. So what we're going to do, we found this interesting Kuwait India BIT, we're going to import it from there. And denial of, instead of denial of justice, I think effective means, we're going to use it, lesser standard, India is. So that's a matter of concern. And I think these are some of the areas which are very well addressed in the Indian body BIT. Now, Mr. Jairaj's point as to why do we have this complex dispute resolution clause. The reason for 5 years was in those 5 years, if you avail that remedy, then it is the fork in the road. Then you don't have an option. And it also gives you 5 years for the court, domestic court, to have their chance. If they fail, they don't perform, then you start investor state arbitration, but don't start immediately. One of the issues that came up, and Ms. Gandhi very rightly spoke about it, there are frequent claims. The reason for claims is there are investors, funders. You go to a funder, the funder takes a share, he finds an investment claim, and then he makes his money. So there's that element which is also driving the market, which we need to be aware of. Very brief final 2 points about the negotiations and answer. Court, what will happen to the court? Colin Brown's from the EU Trade Commissioner, he's leading the mission very well, dear friend. But I doubt if it has a future, because if there's going to be a tribunal of 3, I think the philosophy is to have something like the Iran-US claims tribunal, where there were 2 from one US, one from Iran, and the other was the third national. That won't work because it's not about nationality, it's about the philosophy of a certain scholar. If he's pro-state, pro-investor, how he writes. So there are problems with that. The last point which I want to conclude on is on countermeasures. And I had spoken about this countermeasures at the last ALCO conference as well. What is happening is counterclaims is extremely important. And counterclaims have been put into the cooling box. All the EU states, if you look at them, they say, oh, it's important, we need to discuss. We'll come to it later. And then they say, we are only discussing procedural issues, and counterclaim is a substantive matter. It's not a substantive matter, it's a procedural matter. Counterclaim is extremely important for developing states. Some of the state representatives told me, you need to persuade the Indian government, because if they say something, then everybody follows. So I think counterclaims is the thing which needs to be led. I'm immensely grateful for giving me these few minutes. I hope I haven't transgressed too much into the time. Thank you very much.
Thank you, Anirudh Rajputji, for your views on several of the important issues discussed today. I really want to thank all the panelists for their time and also for their brilliant presentations. I think we are all today more knowledgeable about the issues that we have discussed today, with views shared by the eminent. I'll come, sir. So about the views shared by the eminent, legal minds here, and it would be remiss of me if I don't thank Secretary General Shri Narendra Singh Ji for this, wonderful organization of this ISIL annual conference. This is part of the annual conference, and we are very thankful to you, sir. And I also want to thank my colleague George Potan for assisting me to chair this in terms of inputs and other things. So thank you, George. I'm sure many of you will have many questions, but we have a slightly tight schedule. We have around 5 minutes left, but let me open the floor to everyone, and I think our His Excellency the Ambassador wants to, have a question or make a presentation.
Let me take 2 minutes of the 7 remaining. Make 3 points. First of all, thank you, Chairman, for your wonderful and adept handling of this session, but even more so how you ended your introduction by speaking of the legal system in India. As a resident, I'm equally proud with you being able to say abroad, particularly in the Supreme Court, how we can be proud of the legal system. And secondly, if I go on to what you said about the multilateral investment court, you said that India has a kind of wait-and-see attitude, but I would say that India has been very positive in the analysis of the proposals, including next week we'll be meeting again with Ancestral and the NDA. In fact, my acquaintance with this issue began at a meeting which George invited me to many years ago now. I'd never done any trade law in all my career in the foreign industry as a legal advisor. So I came to this only for the purpose of the multilateral treaty. And there were a couple of things we heard earlier, which I want to kind of correct. I'm not so sure that, by the way, very glad to see Honorable. I can add to what you said that he was very well regarded in the commission, particularly at a very young age, being the chairman of the traffic committee. It's absolutely incredible. People I know spoke very highly of his work there. I was glad to be following him. But I'm somewhat concerned with what you said about from Colin. I don't know what you meant about the choice of the judges in the court to be analyzed. Secondly, the way that Ancestral works, I wouldn't say that it's by majority, it's a consensus operation. And coming to that I would really be very grateful that India were part of the eventual court. They're a leading country in this field now, and I hope that with more concentrated discussion, we'll have you on board as well. I was going to say something about exhaustion of local remedies. I'll do that in the courthouse.
Ambassador, thank you for your views on this, the discussion that we had, and also your suggestions. The floor is open. Please raise your hand and identify yourself. Sir.
My question is more in terms of a layman. I was deeply benighted and impressed by the presentations, but this question which I have is for Ms. Farishte Setna and probably Niyati Gandhi. From what I could understand, it seems to me that the FET is a very important clause in any BIT. I mean, the way you presented it, or the impression that I got was that FET is a very, very significant clause. My question is that if there is a denial of justice or if there is a violation of the FET, all the negotiations, all the discussions for investment, etc., what about that? I mean, does the BIT get called off? Is it the end of the road? Are there consequences? What is the worst fallout that could happen? I mean, is the investment lost to the host country or anything else?
Thank you. Thank you, sir. I think you were saying that as a layman you are asking, but you are asking a very specific, and the question is, pertains to an expert. So I think only experts can answer those questions. So I request Madam Farishte Setna to first respond to that.
Thank you for the question. The way it functions in the BIT world is typically you have to trigger the BIT through issuance of what is called a trigger notice. And the trigger notice allows for negotiation between the investor and the state. And it is only after the stipulated cooling off period that you can effectively then issue what is the notice of arbitration. That is the procedural framework which is very critical to understand. Therefore, there is really no evaporation, as it were, of fair and equitable treatment, because the state certainly has the ability to address or redress, in the first instance, whatever is the breach that is being complained of. And I have to share with you that there are occasions when the state has stepped in and in fact claims that have been brought at the stage of the trigger notice have in fact found settlement very often. So obviously those don't get reported widely, but clearly therefore, to the extent that the FET standard is being made a grievance of, we have even found, as I was just mentioning to Mr. Singh, even through the Indian judiciary, once you have issued what is your trigger notice, and you go to a court in this country, and you mention that we're bringing this matter into your forum, notwithstanding the fact that we have remedies outside of this forum, but obviously in the interests of expediency and time and such, obviously when there are critical issues, for instance, prosecutions, criminalities in regard to foreign investors, we have actually seen courts step up and grant, in fact the Supreme Court very recently last year looked at a case for safe passage for a foreign investor, directed the Bombay High Court to look at that issue, and the Bombay High Court stepped in knowing fully well that independent of the BIT regime that could trigger, there was also the ICCPR protections that the foreign investor was in any event entitled to. So there are multiple facets of how you can go about invoking those remedies, but at the end of the day, yes, legitimate expectation is at the forefront, and no doubt denial of justice would inevitably, in a situation of the type that I was speaking to, inevitably be a grievance, but as Honorable also mentioned, it's a high standard to be met. So therefore, it is inevitably easier to go into your local courts and find remedies if there is.
Thank you, Ms. Setna. Ms. Gandhi, would you like to add something?
I think I would add something very quickly, which is to say that you have to think about fair and equitable treatment the way you think about the doctrine of colorable legislation, or the doctrine of legitimate expectations in administrative and constitutional law. The problem really arises in investment law because constitutional law is interpreted from the lens of India, but international investment law is interpreted from the lens of the investor and protecting foreign investment. So we are making a grievance of it because what are the reasonable restrictions? Whose perspective of reasonable restrictions?
Thank you. Thank you very much. The next question.
I have a quick comment. I'm Dr. G.V. Rao. I'm a senior advocate in the Supreme Court and Vice President of the ISIL. Given the kind of respect India's, has over the years earned and in recent times, and also we have the Hyderabad International Center, which was arbitration center, which has been set up, and something in Mumbai as well, and there's something which we have set up in the gift city in Ahmedabad. I think as investment settlement and arbitration dispute settlement center, we must try to establish India more. As recently I heard the chairman of the India Investment Center said the kind of investment that is flowing into India and some of the cases which we are doing is exponential, it's phenomenal. And therefore not everybody, although Dr. Singh has been saying that both the investor as well as some of the host country recipient want other centers to go to Singapore or London or Paris. But I think if we would like and if we can do, we should try to establish India as the place for settlement of international investment dispute centers and try, of course, we've earned the respect. I think it's an effort we must make in trying to make India as the destination, especially in view of the fact that we are the host country receiving the largest investment in recent times. And that's a comment that I want to make. Thanks so much.
Thank you. I think I would just like to say this very famous thing that your idea, it's not only an idea whose time has come. So thank you. Let me thank once again all the panelists for your time, for your views, for your very insightful views, for taking the questions, clarifying issues. I'm sure we will have other occasions also to seek your guidance, seek your views. And I once again thank Secretary General Narinder Singh Ji for organizing this event as part of the annual conference of ISIL. So thank you very much. Have a nice weekend. Thank you. Thank you.
Your opening.
Thank you.
organize.
Thank you.